Thank you, counsel. You may proceed.
May it please the court, my name is Matthew McLean. I represent Richard Brian Nobles in this appeal, the appellant. This is a post-conviction proceeding in which the appellant alleged several claims of ineffective assistance of counsel. Those issues were briefed, but I think one issue is dispositive in this case, and that regards the confession, and which was not suppressed by trial counsel. Mr. Nobles was in custody at the time interrogation occurred. It's undisputed that Miranda was not given to him. Based off that, any of his statements that he gave should have been suppressed by his attorney in a motion to suppress. Trial counsel failed to do so, although he had a reasonable basis.
What is your support for the statement that he was in custody?
The statement, there's four factors that we analyze in determining whether somebody's in custody, and those are the Ramirez factors. Going through those statements, those factors, there's substantial evidence that was not considered by the court. First, there was two incidents in which the law enforcement investigated Mr. Nobles that day. They came to his house the first time to investigate what they called a hostage situation. They cleared the home after Mr. Nobles let them in, and then they returned later that same evening to investigate him. He was a suspect of allegations of sexual molestation against his biological daughter. They gained access into the home in an unconstitutional way, and once in the home, they directed Mr. Nobles and his wife to remain in the living room while they questioned the alleged victim in this case. After questioning the alleged victim, they went and proceeded to talk to Mr. Nobles and asked him, "Can we talk to you somewhere in private?" It's my argument that Mr. Nobles was in custody at the time he was in the living room, while the other law enforcement officer was questioning his daughter in her bedroom. Mr. Nobles remained in the living room with another officer that was supervising him and his wife, his former wife. Both the former wife and Mr. Nobles testified at the evidentiary hearing that at this time they felt that they were not free to leave, not free to let law enforcement leave, and were essentially amounted to formal arrest at that time. At that point in time, they took it one step further, removed Mr. Nobles from this more public setting in the living room, and brought him into his master bedroom. Two officers dressed in plain clothes, having badges, having guns, then proceeded to question Mr. Nobles about these allegations of sexual molestation against his daughter. They confronted him with evidence. They, before doing that, they had closed the door behind them to make it even more intimate setting. They transformed the master bedroom essentially into an interrogation room. And that's exactly what this court quotes in CFE State, 2000 decision.
Does it matter the context in which this case arrives to the court? Let me amplify, because this comes up in the context of an ineffective assistance of counsel rather than a direct appeal. So the allegation has to be made that the counsel was ineffective, prejudice and skill-wise, to failing to file the motion to suppress. Does that somewhat become obviated if the lawyer testifies, as in this case, that the defendant didn't want to go to trial because he didn't want to put his daughter through this, and other factors as that? Does it change the context and how we analyze the Ramirez factors in terms of the context of this case come up as ineffective? And I'm going to stop now because I don't want to use all your time trying to frame a coaching question.
Yes, it absolutely does take into consideration whether Mr. Nobles would have still proceeded to trial. And he testified at the evidentiary hearing that he asked his trial counsel, "Can we file this motion to suppress?" His trial counsel firmly told, "You have no grounds. You weren't in custody." And also in regards to the warrantless entry, there was no grounds to do that either. Mr. Nobles testified that had he been aware that there were these grounds in which he could suppress, ultimately what trial counsel deemed, in his own words, very significant not only to go to trial, but also in plea negotiations, he would have filed a motion to suppress. This isn't somebody who got a fantastic deal. He got 40 years in prison. He was 37 years at the time that this offense occurred. He'd be 77 when he got out of prison. So he had all the reason to go ahead and file what defense counsel ultimately admitted to being a non-frivolous motion. He did go through the Ramirez factors at the evidentiary hearing, and he essentially admitted that 3 of the 4 factors were met. He didn't have any recollection in regards to the 4th factor. So the basis that Mr. Nobles was advised that there was no grounds to suppress this evidence made him believe that he did not have a very good chance at going to trial.
What would have been the maximum possible sentence he faced if he went to trial?
It would have been life.
Right.
Correct. But, I believe that a 40-year sentence when 37 years old is tantamount to a life sentence. The average life expectancy is probably below 77. So in this case, he did not obtain a fantastic deal, and his trial counsel told him that he had a 0.1% chance of succeeding at trial. So coupled with his trial counsel telling him you have a 0.1% chance at winning a trial.
Well, I think you're probably focusing on the deficient performance prong of this for obvious reasons, and that's because it's really hard to see the prejudice here. So would you, I think you gave us about 2 or 3 sentences on that. Could you elaborate?
Absolutely. The prejudice in this case is the ultimate evidence in this case against Mr. Nobles was his confession. It went exactly to allegations of sexual molestation. And if this testimony was not there, it would have significantly changed his posture, not only in the plea setting, but also going to trial. So he was prejudiced by the fact that he would not have entered the plea, and he would have pursued a non-frivolous motion.
But we have to evaluate the credibility of his statement that I wouldn't have entered the plea.
When you evaluate
that's part of the prejudice analysis, isn't it?
Absolutely.
And so what factors play into the credibility? Anyone can say, I wouldn't have entered the plea, but you have to look at the totality of the circumstances surrounding the plea, right?
Sure, absolutely. And I think you have to...
And so what were those?
You have to look at the fact that he affirmatively approached his defense counsel wanting to suppress this evidence because he deemed it significant evidence against him. So the fact that he got a 40-year deal, there probably wouldn't have been...
What about the Facebook exchange that precipitated this investigation?
The Facebook exchange occurred on an application card called Farmville. And in Farmville, there was a conversation with another person in Georgia that led to an FBI tip that he was molesting his daughter. So that's some evidence that could be used.
What about statements from his daughter?
And those are all evidence that could be presented at trial. But again, significant evidence against him was his confession, in which he admitted to allegations of sexual molestation. The evidence doesn't get any stronger when there's a confession, and trial counsel noted that. So I think in this case, when we look at the prejudice, it was substantial in this case. We're not talking about a small piece of evidence in this case. We're talking about the piece of evidence in this case, and those are his own statements. A jury hearing his own statements that he sexually abused his daughter would go much farther than
as part of the prejudice analysis, is there any evidence in this record that we could focus upon that would suggest that were the child to testify, she would not be credible?
There is no evidence in this.
Tactically speaking, the appellant here would not be taking the stand to testify, right? Because if he takes a stand to testify contrary to his confession, then the confession would come in for impeachment. So tactically speaking, the lawyer is left with a position where I have a child who may not be impeachable, and I'm hoping, or I'm going to work to get a reasonable doubt. Is that basically the tactical theory to go to trial?
Sure, I would agree with that posture. And I think we also have to note, too, the trial court's order here did not address the prejudice prong.
Did the trial court's order ever address Ramirez at all?
No, it addressed Ramirez in a very limited context. They simply focused on the fact that it was in a calm, relaxed manner. A recorded portion of the interrogation that occurred. And that's significant here because it was a partially recorded interrogation. This was a 45-minute interrogation that occurred, and only 15 minutes was recorded. And the court and the state puts all their weight in the fact that Mr. Nobles appeared to be in a calm, relaxed manner answering questions. What's significant, he was never advised of his Miranda warnings. The Fifth Amendment protects somebody's right to be free from being compelled or coerced into being a witness against himself, to be free from self-incrimination. He was not given that opportunity by law enforcement, and yet they try to cure it at the end by stating, did he feel free and voluntary and uncoerced to give this statement? And when we go ahead and look at the cases, that's not dispositive. Ramirez v. State the same exact waiver was discussed. Ramirez v. State, the officer testified, but I asked him afterwards whether he felt voluntary, coerced, anything of that sort. And Mr. Ramirez said, the only thing you promised me was that you would be my friend. But other than that, everything I said was the same thing.
Why isn't this a strategy decision by the attorney looking at the strength of the case to decide, look, if I start filing motions and contesting this, I'm going to end up in a worse situation because I'm not going to get any kind of offer whatsoever. And this case is so strong, and in the post-conviction order, some of the steps that the lawyer took are indicated there, that his strategy going in, and wouldn't it be a reasonable one, was to just save something other than this gentleman going to trial and getting life. Why isn't that an acceptable strategy in this case?
I don't think that necessarily was his strategy. He also testified that whenever there's a confession, he wants to get that out because that significantly impacts negotiations, getting a better deal, the state's case is weaker, and also going to trial. And so although he did testify he wanted to get a better deal, this was a 40-year deal. This is tantamount to a life sentence.
Would we have to conclude that not only should the suppression motion have been made, but that it would have been granted in order to grant you relief?
I don't think so. Under Hill v. Lockhart, the standard is whether, had he been given reasonable...
But don't you need us to decide that in order to show prejudice?
I think the standard is that he would have not entered a plea, but for this Constitution deficient performance. Would he have proceeded forward with his motion to suppress and not entered the plea? Well, I think it's highly indicative that if the motion to suppress was granted, that would be a very strong case. But I think we also have to analyze it for the fact, what was in the defendant's mind at the time he entered the plea, and would he have entered the plea had he had the opportunity to pursue this non-frivolous motion to suppress the key evidence in this case. So I think that's what the standard would be analyzed. But I do believe that if this court finds a motion to suppress would have been granted, that is a big strength to his case, and I do think had one been filed, it would have been granted. And it's important to know, had it been filed, it would have been the burden of the state to go forward with showing that this was a voluntary confession that was made, not in compliance with Miranda. So because Miranda was not given, all these statements he made should have been suppressed. Talking about the cases of CF and Lee, the state tries to distinguish them based off the fact that these individuals were minor, and the same is true with Ramirez. While Mr. Nobles is not a minor, 37 years old, he testified at the evidentiary hearing he had no experience with law enforcement. So similar to CF, Lee, and Ramirez, he's also unsophisticated in regards to the legal system. Any reasonable person in his situation, being unannounced, law enforcement arriving to your house, coming in, investigating your daughter, having you sit in the living room while being supervised, being moved to the bedroom in a private setting with the door shut, coming in and out, shutting the door behind them every single time, would not feel free to leave. That amounted to formal arrest at that time, essentially. Also in Killian, they talk about the state that there was no search warrant. That's how they distinguished Killian. However, there was still an investigation going on in the Nobles' home, just as if there was in Killian. In Killian, there was a search warrant that was given and being executed at the time in which Killian was directed to stay outside and was under supervision as well. In this case, law enforcement came into the home and conducted an investigation while directing him, stay in your home, stay in the living room, and having an officer hover over him. And they said so in an authoritative voice. This court's order is deficient. I know that this court does give deference to its factual findings. However, it only made factual findings, I think, in regards to one of the Ramirez factors. And that's simply the way the interrogation was conducted in a calm, relaxed manner. It didn't weigh in any of the factors, any of the things that went to Mr. Nobles' position that he was in custody, that he was not advised that he was free to leave, that he was confronted with evidence of his guilt, that this was done in a private master bedroom with the door closed with two officers in the bedroom while he sit down in a submissive position. All these factors tend to show that Mr. Nobles was in custody, and therefore counsel was deficient. Counsel was also deficient performance prejudiced Mr. Nobles in this case as well. And also,
15.
What's that?
You didn't tell me much time to reserve, but you're at 15.
Okay, I'll go ahead and reserve the rest for rebuttal. Thank you.
That's your call.
May it please the court, Brandon Christian for the state of Florida. The state in this case charged Mr. Nobles with 2 counts of capital sexual battery and 4 counts of lewd and lascivious molestation. The capital sexual battery charges were punishable by a mandatory term of life imprisonment. The other charges were life felonies. So he entered a plea to a reduced charge of attempted capital sexual battery. And what that allowed him to do was to receive 40 years in prison, concurrent terms, with the possibility of gain time. He has the possibility of release within his lifetime, and then it would be followed by a lifetime term of sex offender probation. And the reason I emphasize that to start out is that that goes to his credibility in making all of these claims. He's raised some technical issues. He's raised the Miranda issue, which I'll address. But overall, he needs to come up with something that would have caused him to proceed to trial on 2 charges that were punishable by terms of life in prison. And not only that, but the evidence against him included not just his own confession, it also included the testimony of the victim in this case. And as the panel has already mentioned, just because her testimony could have conceivably been excluded as hearsay, the state can still call her and present her as a witness. She was 11 at the time of these offenses. The defendant was 36 at the time of the offenses. So there's nothing in the record that would indicate to me that the state would have been prevented from simply calling her as a witness. And I mention that issue just because the CPT DVD is mentioned. That's one of the claims that he's raised. But moving on to the Miranda issue, the trial court conducted an evidentiary hearing on that issue. It heard from defense counsel, and it heard from defense counsel's associate. It also heard from Mr. Nobles, and it heard from Mr. Nobles' then ex-wife. On this issue, I think the strongest evidence in the state's favor is probably the recording of the interview itself. The panel can certainly listen to the recording. It's in the record. There's a transcript of the recording in the record. The tape-recorded part of that interview, it reveals a very calm and relaxed manner in which this exchange occurred. This was really more of what I would characterize as it's more of an interview as opposed to an interrogation. There's a conversational tone. They're not, certainly not aggressively posing questions or manipulating him or misleading him. At the conclusion of that interview, the appellant made statements, and he was asked, and he confirmed that Detective Powell did not make the appellant talk to him. He didn't. Detective Powell asked to come and talk. And they asked for a private place to talk about these allegations. That's why the bedroom comes up and they shut the door. Again, these were serious allegations involving a family member. The wife was, from the record, was ill essentially as soon as the officers came up and mentioned what might have happened. So they shut the door. That's one of the circumstances that would weigh into a Miranda analysis. Detective Powell, the appellant confirmed that Detective Powell did not force force the appellant to come and talk to him. And the appellant also confirmed that he was not coerced in any way, and he said that he talked to the detective voluntarily. And so all of those things are on the tape. The defense counsel then was presented with, the audio recording of this. He could have talked to his client about this. He had a good sense, I think, of how this circumstance came about, and did he have a basis to file a motion or not? The analysis here is not whether he could have filed a motion to suppress a confession based on Miranda, but whether he made a reasonable decision in weighing all of the circumstances and choosing not to file the motion and instead to essentially focus on obtaining the best offer for Mr. Nobles that he could. The record strongly supports the trial court's conclusion that defense counsel made a reasonable decision in this regard. Again, it's not whether he could have filed the motion or, certainly he could have filed a motion here. These were serious charges. I won't deny that. But he also carried a risk to file this motion. There was a possibility that the state's going to withdraw the offer of 40 years. And so, he could have simply made matters worse by doing that. And so, as far as the deficiency prong, the record supports the trial court's finding on that point. In terms of the prejudice prong of Strickland, the question of whether this would have been a viable motion, Judge Black asked about this, it simply goes to the defendant's credibility. I know it's an awkward thing to kind of think, well, would this have prevailed or not? At the end of the day, what the case law says is that the issue of whether this defense might have been viable, it goes to the defendant's credibility in claiming that he would have proceeded to trial rather than enter his plea. Here, there's not a showing that this motion would have been successful, so it's a stretch to say that, hey, I would have proceeded to trial if my counsel had filed this motion. The other claim I wanted to address in particular, it was one of the summary denial claims, and Mr. Nobles had argued that he was pressured or coerced into proceeding to enter his plea, and that specifically that his attorney pressured him to enter his plea because his attorney wanted more money, and was demanding more money to go to trial. So in denying that claim, the trial court attached the retainer agreement. I think the gist of that is to basically say, well, look, he was entitled to ask for more money because that's what the retainer agreement says. Candidly, I think that's a sensitive issue. I don't think an attorney can just say, well, you're out of luck because, I need more money.
The trial court will make the determination if counsel is allowed to withdraw.
Did the trial court?
That's who will make the decision if counsel
Right.
will be allowed to withdraw.
Right. So here the trial court attached the retainer agreement, and then the trial court also attached portions of the plea colloquy. The colloquy that we have, it contains the question saying, well, did anyone pressure you or coerce you? Unfortunately, the record doesn't have the page after that when Mr. Nobles would have said yes or no. However, the record does have, in the immediately following page, the question where the court says, are you satisfied with the advice and representation that's been provided by your counsel? Mr. Nobles says yes. And I would just submit that on these facts that is sufficient to conclusively refute his claim that his attorney...
But wasn't his point really that he didn't understand that if his attorney did withdraw, he would not be provided with counsel, that his point was, I thought I was going to have to go to trial with no lawyer?
Right.
Isn't that really what his claim was?
Perhaps it is. With this case, his defense was being, as I understand it, was being funded by his parents. He has a private retained lawyer, even though he is indigent.
He
would have received the benefit of the public defender if his attorney had withdrawn.
Right, but his claim is, I didn't know that.
Right. Well, I don't know that. I don't believe that establishes a basis for him to withdraw. If he really didn't understand that and his attorney was, threatening to withdraw, I don't see that it's reasonable that he would have testified under oath.
I think his point on appeal, if I remember correctly, is that there should have been an evidentiary hearing on this, that the record did not conclusively refute his allegation that he did not understand he would receive appointed counsel if his lawyer did withdraw.
Right.
So is there something in the record that would refute that?
Well, I don't know for certain whether that would be deficient on these facts for his attorney to simply say, you owe me more money. The attorney, sure, the attorney could have said, well, yeah, you might get the public defender, you might not. the attorney has to ask the court to allow him to withdraw, and I would assume that that would all be addressed as part of the process of withdrawing. So I don't know that he can establish any prejudice by saying, well, I wasn't sure whether I was going to get the public defender or not. And again, I would just reiterate that his...
Do you need an evidentiary hearing to make that determination if you're the trial court?
Based on the fact that he says he's satisfied with the representation provided by his counsel, I don't believe that an evidentiary hearing was necessary on that point. We have portions of the plea colloquy, and we have the portion where he says I was satisfied. I think the record also went well. Yeah, I understand the court's point. I just would emphasize that again, he's testifying under oath that he's satisfied with everything his attorney said. If indeed his attorney was threatening to withdraw and not proceed to trial, as Mr. Nobles is claiming he wanted to do, it's not reasonable to say that he would have gotten up in court and acknowledged under oath that he's satisfied with the representation of this attorney. So that's one of the summary denial claims. He's also raised an issue regarding the warrantless entry. The court on that issue simply found that the ex-wife's testimony, it focused on the ex-wife testimony because she says, well, I don't remember whether I allowed them, whether I gave consent.
At this moment, this is an involuntarily dismissed complaint, right?
Right.
So at this point, the record before the trial court says, Mr. Noble says, I did not give them permission, and the wife equivocates.
No.
Is that correct?
No, Mr. Nobles did not say it. Well, he says yeah, that's true.
Here's the reason why. Because under the Fourth Amendment, the state has the burden of showing they have a warrant to enter the house. If they don't have a warrant, the state has the burden of establishing the exception to the warrant requirement, which arguably in this case might be consent. At the time of the involuntary dismissal, what evidence did the trial court have that there was either a warrant or consent? And if the answer to that is none, then there's a question of whether that's an error. And then the next question, is it harmless? Because I understand the police officer comes up later and says, they both gave me consent.
Sure. And essentially that would be my analysis, was that this is harmless error on these facts because the detective testifies that he received consent.
But does that also assume that the trial court is going to find the police officer on this particular issue credible? We have no inclination at this point, unless there's something in the written order that says the consent, maybe that would be the argument, because he does say that in the written order, I believe, the trial court does say that. Now, I'm concerned that the trial court has skipped an analytical step here.
The trial court did find in its written order that consent to enter was given, so I don't, there has not been a step that was skipped. I agree, I think that moving for involuntary dismissal didn't serve any purpose, and we had the officers there ready to testify. I think it was simply maybe a little bit of overzealousness by the prosecutor, but it wasn't necessary. They had the officers there, and then the officers get up on the stand, and we can ask, they can ask them all the questions about this particular issue. So once we have officers who are testifying, well, I gave consent. In terms of a Strickland analysis, he didn't establish anything that his attorney would have been unreasonable in not filing that motion. I recognize that the warrantless entry analysis is a little bit different, but in terms of, well, was his attorney reasonable? He didn't present anything to show, this was his burden at the evidentiary hearing. He didn't present anything to show that his attorney was acted unreasonably in not pursuing that particular issue. I think he would have needed to come forward with some kind of testimony, perhaps, that his wife really didn't give consent. So that's the warrantless entry issue. Unless the panel has any further questions, I did mention the discovery and the child hearsay issues. Again, I think Mr. Nobles needs to identify something as to those issues that would be a substantive problem. Simply saying, well, I didn't get discovery, that's not going to explain why he would have proceeded to trial on these charges. The child hearsay issue, again, my concern, my understanding there is that this victim could have been called to testify at trial regardless of the outcome of that child hearsay hearing. So he's unable to make any credible claim that he would have proceeded to trial, depending on the outcome of that particular hearing. So in conclusion, the state would ask that the court affirm the lower court's order denying Mr. Noble's motion for post-conviction relief. Thank you.
May it please the court. Just beginning with the warrantless entry, I think you are correct with the 1.420 involuntary dismissal. At that point in time, all inferences were supposed to be taken in favor of the appellant. That was not done. The fact that officers testified after that involuntary dismissal occurred that they were given consent was not an issue at dispute, so it was never contested after that point, never cross-examined that officer on that point, because it simply was not an issue at that time. The involuntary dismissal had been granted at that time. So it was generic to other questioning regarding the coerced confession and the failure to give Miranda. So based off that, it's not harmless in this situation, and an evidentiary hearing, a full evidentiary hearing should have been occurred on that because we did meet the prima facie case for it. In regards to Judge Kelly's point on the attorney and whether who's advised is the right to be appointed by attorney, I think this court need only look directly at Luma v. State. That's at 736 Southern 2nd, 1290. It's identical facts. And in this case, we can't assume what would have happened, and that's essentially what the state has asked this court to go ahead and do, assume that this would have happened at an evidentiary hearing. But we can't assume because an evidentiary hearing on this issue was never held. Mr. Noble should be entitled to that. Finally, turning to the prejudice prong in relation to the unmirandized confession, we need to go ahead and look. The state brings forward the fact that maybe this deal wouldn't still have been on the table. But that's not the point we have to look at. Is defense counsel was still trying to defend his client. He proceeded forward with the child hearsay hearing. At that child hearsay hearing, he was trying to get rid of evidence. So in addition to trying to get rid of that child hearsay evidence, he could have got rid of Mr. Noble's confession. And in fact, that child hearsay evidence was corroborated, and the court found it admissible because of Mr. Noble's confession. So had that not been used to get the child hearsay evidence in, this might be an entirely different case where they don't have child hearsay evidence and they don't have Mr. Noble's confession. Both those things are significant in this case, and defense counsel should have done his job and filed a motion to suppress. There was United States Supreme precedent. There's Florida Supreme Court precedent. There's precedent from this court that allows for this to be suppressed. Defense counsel simply did not do that. Mr. Nobles was prejudiced. And the 40-year deal was the same deal that defense counsel called at the evidentiary hearing a bad deal. He talked about it with his client. This is a bad deal. I'm sorry, this is a bad deal. The deal never got better. The deal was 40 years at the beginning. The deal was 40 years at the day of trial in which he accepted it. That deal wasn't going anywhere. So there was all the opportunity for Mr. Nobles to go ahead and try to defend himself.
At the plea hearing, did Mr. Nobles receive any other benefit, any plea reduction or anything like that?
No, he pled guilty to all the charges against him.
As charged.
Correct. So he did not get benefit of some plea. He got the benefit of 40 years, but that's, again, tantamount to life.
I thought the plea was to attempted.
I believe it was not to attempted. I'll have to...
The reason I asked that question is counsel for the Attorney General's office said it pled to attempted. I understood the original charges was sex bad. So that might be a point upon of interest to make sure that we know exactly if there's a dispute in the record, we can check it out.
Your Honor, my record, and it's cited at record page 9, is that Mr. Nobles was charged with 6 counts. The trial court sentenced Mr. Nobles to 30 years incarceration as to 2 counts of sexual battery and 40 years incarceration as to the 4 counts of lewd molestation. So he pled as charged to the information. That's record page number 9. So he did not receive any other benefit in dropping charges. So at this point in time, rely on the brief We ask that this court remand for Mr. Nobles' plea to be withdrawn and for him to proceed forward with effective assistance of counsel so that he can pursue not only a motion to suppress but any other motion that he deems appropriate going forward. And that would probably have to do with the child hearsay hearing as well, due to the fact that it's related to the admissibility of his un-Mirandized confession. Mr. Nobles received an effective assistance of counsel, entitles him to relief. Thank you very much.
Thank you, counsel. Thank you both.